Hello, hello. Am I audible? Hello, can you please mention it in comments and let me know whether I'm audible right now or not? Okay. Thank you, Yamandeep. Thank you so much. Thank you, Ame. I'm sorry I mispronounced your name earlier. Now I'm audible. Okay, fine. Thank you so much. So let me just quickly repeat what I said earlier. This is your index for today. We are going to discuss, as you all know, we are in 10th week of our initiative. Today is Friday. I am Drishti, and we are going to cover these three major topics related to your internal security and social issues now. Thank you everyone for letting me know. Good. So let's get started. Your first issue is related to, sorry about the fumble, reporting cyber attacks. So the agency, that is Cert-In, the nodal agency for cyber security in India, they have released a couple of guidelines, right? So we'll go through that, what the guidelines are, how it impacts cyber security in India, how the networking has been happening, what is the protocol designed for it, right? We're going to discuss that in detail. Then we are going to discuss NATGRID. NATGRID is your national intelligence grid, right? It was formed after the Mumbai attacks, and how it all has been functioning, what agencies are related to it. Recently, Home Minister has inaugurated a center in Bangalore, so we are going to discuss that in detail. And then we are going to discuss about under trials. What under trials are, we have already discussed prison reforms earlier, right? There we discussed Ministry of Home Affairs had released a sort of guidelines for the improvement of prisons. Today we are going to discuss what under trials are, how they have been occupied, because as per international standards, India may the amount of prisoners in the jails is tremendously high, right? Even if you compare to other countries, India may the percentage is around 75%, which is exorbitantly high, and this needs our serious attention. What impacts it has had, the law commission report, it has given a couple of recommendations. We'll discuss Supreme Court guidelines, and then we'll discuss the government of India, what initiatives they have taken and what can be the way forward for it, right? So let's get started. So as I told you, India's nodal as in the whole soul, nodal cyber security agency, computer emergency response team, that is known as Cert-In has taken steps to prevent cyber breaches. They have given a couple of guidelines, and let me tell you about Cert-In. Cert-In was formed in 2004, and it is under the direct control of Ministry of Electronics and Telecom, METI, right? Please remember this, formed in 2004 and under direct control of METI. So these are the recommendations that have been given by Cert-In recently. See, as we have already discussed, we live in the age of cyber warfare, right? Border pe ladne ka, arms and ammunition se, wo cheezein na, that chances have reduced a lot. Now we live in a era of biological warfare and your cyber warfare, right? We have already discussed how much of attacks have been happening globally, how much attacked India is, right? And the measures we have taken, how weak is our cyber policy. We do not have a dedicated team which is enough to take into account or secure the actual people who have been using internet. We have already discussed dark web. If you have not seen those videos, please go through them, so you'll get to know what I'm talking about, right? And as we have already seen how a single breach in cyber warfare can humongously impact the security of a country. If you breach in, you can disrupt telecom, you can disrupt their missile system, as has been evident in Russia, Ukraine, also in Natanz facility, the nuclear facilities. The examples are enormous, right? So let's see what Cert-In has said. So the directions, they have been issued under this act, subsection 6 of section 70B of IT Act of 2000, right? So under this act the orders have been given, right? Now all service providers, intermediaries, the data centers, if there is any sort of security breach, all these institutions, if there is any sort of security breach, they have to make sure that they report this to the concerned authority within 6 hours. This is the most important part, right? We report this within 6 hours. So this is the most important point here. Now the new directions, they require your virtual assets. Virtual assets means whatever is in place in your software domain, right? Virtual asset exchange, then your custodial wallet. Custodian wallet as in, for example, you know, you use these Paytm has its own wallet, they have transaction history, right? They have money in it. So whatever intermediary is controlling your or watching, monitoring your digital movements, they have a wallet where all your data is stored. So the custodian wallet providers, they have to keep a record, past record for the period of 5 years. Whatever transactions that have happened, they have to keep a record of it for 5 years, right? Then companies that have been providing your VPN, virtual private network, they will also have to register their and validated names, emails and their IP addresses to the subscribers that Cert-In has mandated. This is very important because it's a new policy with regard to the cyber security in India, and considering the current world scenario, we can surely expect at least one, maybe more than one, but at least one question in your mains, UPSC mains this year. Now the information and assistance to Cert-In, that has to be given by the all these custodian wallet holders and IP and address providers, etc., etc. Whatever the intermediaries are, if just in case any cyber incident happens, any sort of mishap happens, then Cert-In has the authority to demand for all sort of assistance, including their logs, digital logs for everything. Hence they have to keep the record at least for 5 years, right? Now to connect and synchronize all their ICT systems, particularly their digital ICT systems, they will have to synchronize their clocks to either NIC, National Informatics Center, or National Physical Laboratory, right? Now the important part here is, what is NTP? NTP is a protocol where there is a systematic exchange of data, right? Systematic exchange of data which actually synchronizes the internal clock of a computer to a common standardized computer. That computer timer can be of either NIC or National Physical Laboratory, right? So these are the major guidelines. Now if you come to the provisions that have already been there in India's cyber security policy and international standards, let's discuss those. What are the clauses that are already there? Now for any sort of cyber breach, cyber crime, clause 25 in the Data Protection Bill of 2021, it says that data fiduciaries or whatever the concerned authority is, they have to point it out within 72 hours of breach, 72 hours of actually becoming aware of the breach. It can happen that there is couple of hours lag of knowing. वैसे तो आजकल the technology has advanced to such a level that if there is a breach, you immediately know about it, but within the knowledge of 72 hours of breach, the concerned authority must be informed, right? Then clause in EU GDPR. EU GDPR is considered as the golden standard for cyber policies all around the world. It is European Union's General Data Protection Regulation, right? This was set way before the cyber policies of the world evolved. So this is considered as the golden standard. Now there is a clause in EU GDPR as well, which provides that if there is any sort of security breach, you have to report it and deal with it within a stringent timeline. Right, now let's come forward to what can be the way forward recording it. Right, there has to be periodic cyber security audits. This has practically been done in some countries of the West, but in India there is still plan over it. Right, now we have to empanel third party auditors. Only a couple of countries which are technologically very advanced like Israel have been doing this, but in India this can be done considering the mammoth amount of security data, cyber security data we have. Right, now evaluation and certification of cyber security. This is something which can be the core principle of our cyber security policy. For example, how we demarcate the standard for any sort of food product is done by Food Standard Security of India, right? Similarly, there can be evaluation and certification of cyber security by a standardized authority, so that can be set up in India. Then security command center can be set up. This has been done privately by IBM in the Silicon Valley, and this can be replicated as an example all over the India, right? So this is couple of things, these are the couple of things that you can mention in your paper, and if we follow these, we can actually create a space that is holistically safer for India and create a safe cyber security space for people in general, right? So I hope everything is clear about the cyber security policy, what Cert-In has said. Now let's come to our second topic of the day. Our second topic is NATGRID. NATGRID refers to your National Intelligence Grid, and recently it was in news because your Union Home Minister Amit Shah ji, he inaugurated NATGRID camp in Bangalore, right? He recently inaugurated NATGRID camp in Bangalore, and basically what is NATGRID? NATGRID is India's ambitious counter-terrorism program. And this policy came into place, the whole evolution of NATGRID came into place after the Mumbai attacks of 26/11 in 2008, right? After the whole Headley fiasco happened, right? The terrorism, we received such a jolt in the heart of Mumbai. After that, the then Minister of Security, P. Chidambaram, decided to upgrade India's security, and then the whole concept of NATGRID came into place. Right, now what NATGRID does is it essentially collaborates your 21 points of accesses of citizens and collects a data of it, which is shared by around 11 or more agencies. Right now only 11 agencies are listed, and it shares the data among those 11 agencies so that essential steps can be taken for the security of the country, right? So the initial budget was of 1200 crore and it came into existence, NATGRID came into existence into 2018. It was fully functional. It was started in bits and pieces, right? It was started in small pilot projects, and it became fully functional in 2018. Now what it does is it collects data from around 21 digital parameters. For example, your unique identification number, basically it refers to your Aadhaar card. Everything we have come into a place, a era where everything has been linked to your Aadhaar card, PAN card, etc., etc., and everything has been digitally linked. So since everything has been linked to your Aadhaar card, your unique identification number, the grid intelligence, it collects data about your movements, your transactions from there and then itself. Then your vehicle registration number and your driving license. Third comes your mobile call details and your phone connections. Fourth is your bank account, your credits, your insurance details, your loans, etc., etc., whatever is there, right? Then your stock exchange investment details, whatever, how much money you have invested in stock, so that the black money, the money that is or can be used for the terrorism activities, acts of terrorism, that can be accounted for. Then your train reservations, all sort of transportation that you have been going through, for whether it is your railway tickets, your air tickets, bus tickets, etc., etc., whatever you have booked. Your passport data and reservation and immigration data. All this has been collected, is being continuously collected by NATGRID. Now, this data is accessible to these agencies. I'm pretty sure this is, maybe because this is a very old infographic, I'm sorry I could not find a better quality of it, right? So, I'm just speaking, please listen to it, which agencies it is available to. National Investigation Agency, your NIA, then Intelligence Bureau, IB, Research and Analysis Wing, Defense Intelligence Agency, Military Intelligence, Directorate of Air Intelligence, Directorate of Naval Intelligence, Directorate of Revenue Intelligence, Enforcement Directorate, National Security Council, and Central Bureau of Investigation, your CBI. The infographic might not be visible right now, but you can see this properly when you receive the PDF of the same. You can receive, you'll receive the PDF just after the session in your Telegram groups, for which the link you can find in the description box. You have doubts about Punjab PCS, okay. You can ask those doubts, I guess, after you've prepared for UPSC, or you can call to our given numbers and then you can discuss that. Now, this is another infographic. It shows the name of the agencies that I've already told you, right? And we have already discussed money transfer, internet service, telecom, etc., etc., the whole gamut of it, right? This we have discussed. Now, a couple of details about your NATGRID. In 2020, NATGRID had signed a MOU with NCRB, National Crime Records Bureau, and it will give access to all the filed FIRs and reports of stolen vehicles to NATGRID. See, most of the times, the stolen vehicles are used for the acts of terrorism, whether it is bomb blasts or for transportation, etc., etc. So, all this data, the access will be given to NATGRID, right? Now, वैसे तो the FIRs, they are registered by police, and police, the whole administration, police administration comes under state subject as listed in your 7th schedule of the constitution. But NATGRID actually hopes to, and the main core objective of NATGRID is to provide a centralized stable data repository of all the FIRs that have been filed by the various police states, police of various states, so that the data could be interchanged and the culprits can be caught as soon as possible. Now, as I told you, police is the part of your 7th schedule, but around 1400 police stations, they have to register their data into the NATGRID portfolio. Now, your NATGRID is exempted from RTI Act just on the lines of, because the question arises of national security, right? So, if you think you can get some information about NATGRID, the details of it, the data of it, it is exempted from RTI under section 24, right? Now comes their NATGRID was formed, but there were a lot of there was a lot of opposition on the lines of privacy breaches. People were not comfortable with the formation of NATGRID, but here came what is basically the need of NATGRID. So NATGRID was essentially made because otherwise the means which police devised or used to extract the information out of suspected people was very coercive and harsh. For example, third degree torture, and sometimes it resulted into deaths and unnecessary emotional, mental and physical harassment of the accused culprit, right? So this was the foremost reason, so that we could keep a watch on people, and by looking after their suspicious activities, we have some hardcore evidence before arresting them and unnecessarily not torturing them to death, right? Now, rounding up suspects which most of the time were innocent, right? They might be involved into petty crimes, but that cannot be equated with terrorism. See, there are levels of crimes. So someone who is a thief cannot be held responsible for the act of terrorism, but because of the suspicious activities which police arrested them just on the basis of how they were behaving, etc., etc., they ended up, innocent people ended up in jails. So avoiding them and ultimately avoiding the human right violations, NATGRID was essentially necessary. Now we could keep tab on people, suspicious people, that was the foremost objective, and the ultimate objective was the police would have access to all these movements, right? And they could track the person with the help of database. Police of Jammu Kashmir can track someone in Kerala. So that was our basic motive, that all the police stations could track the illegal activities, the terrorist activities all over the India smoothly, and there is a proper coordination and synchronization among the legal bodies, the legal bodies of the country, right? Now, basic criticism was possible violation of privacy. See, tapping into phones, keeping a record of your bank transaction, it is somewhere breach of your privacy, right? So, possible violations of breach of privacy and the possibility of leakage of confidential personal information. Personal information to people. See, there has been a lot of buzz all around the world about your breach of privacy. Right now, your artificial intelligence have evolved in such a manner. Also, India does not have a proper dedicated enabled cyber security protection cell, right? So possible violations of privacy breach was the prime concern. Then the efficacy of NATGRID in preventing terrorism has also been questioned. Why? Because police force does not have access to it. It can be only accessed by the 11 agencies I've already discussed with you. So efficacy in preventing terrorism, if the police does not have access to it, has been brought into light time and again. Then misuse of the data, such huge amount of data collected by NATGRID has been prime concern about activists and people all around. Now, there is possible that multiple agencies are undergoing or taking on multiple operations. So, if data about that is made public to other agencies as well, there rises two scenarios. A, it hampers their territorial jurisdiction, and B, what happens is it somehow impinges on their ongoing investigation. So these are the criticisms that have been given by the people and the activists all over, but NATGRID is functional, the data is being collected. Let's see how it evolves in future, but right now this is the status, and a new camp has been recently inaugurated by Home Minister. So let's see how it further evolves. Now let's come to our third and final topic of the day. Our third topic is about prison reforms. Prison reforms, that too about under trials. Under trials were in news. Why? Because recently Prime Minister of India was speaking at the 39th conference of Chief Ministers and Chief Justices, and he has pressed for early release of 3.5 lakh under trial prisoners, and he has requested the Chief Ministers and Chief Justices to focus on resolving on this issue, right? So this has been going on. India has 75% of under trials right now, which is improper, inhumane to keep the people who are still waiting their trial. I already told you, as per NCRB, I have already discussed in the previous video, for a prisoner just to get to the court, just to know whether you will be getting sentenced to some sort of punishment or whether you will be acquitted, it takes around 2 months to 5 years of time. So if a person has to wait 5 years just to get heard, what is the point of the whole process of judiciary, right? So this has come into question, that this unnecessary or inhumane suffering of people who are somewhere innocent, who do not deserve round about this much amount of time in jails, is being questioned, right? Also in 2019, on when COVID pandemic was on its peak, even then Supreme Court directed that people who are under trial from a very long period of time, they must be released on the grounds of humanitarian basis, right? Now let's see what are under trials basically. So under trials is a person who is in a judicial custody or remand, and during investigation, and the person is still unconvicted. It is still unknown whether the person has actually done the crime and still waiting his sentence, right? If you see by international standards, as I already told you, for example, the amount of under trials in UK, it's 11%, in US is 20% and 29% in France, and it is 75% in India, right? According to NCRB data, इसमें से भी around 55% are Dalits, Muslims or Adivasis, and the major reason because they form such a big chunk of our prison system is because half of them are illiterate, they don't know their rights, and they are uneducated. So this is the major reason they end up in the criminal system, because they do not know about the laws or about their lives or about their rights, right? Now 42% of the under trials, they have not completed their secondary education. As I said, they are uneducated and illiterate. They do not know, the person who does not even know about the basic secondary education, how can you expect them to know about their rights, about their legal rights? So this is something that has to be pondered upon. This is something that comes into question, right? Now what are the reasons that have been there for this delay in justice, right? So your first and foremost reason is your overburdened judiciary. A lot of buzz has been going around about recruitment in judiciary, right? Even the judges have been appealing that there are many seats vacant in the judges collegium system, please fill those. So overburdened judiciary as compared to cases that are filed, and as compared to the number of prisoners that are there, the judiciary currently is overburdened. Then the prison officials, their role, whatever assistance they have to provide, that comes into question a lot many times. Then there are disadvantaged social groups, as I told you, tribal people who, for example, someone who lives in extreme tribal areas of Nagaland does not know does not know what the law is, what their right is, and somehow they end up violating some law and they're captured by the police and kept in jails. They do it, they have done it unintentionally, but that does not make them a criminal. That is just a lapse on their part. So for them, they have to pay a heavy price, and this is a huge problem. Then even our prison system is understaffed, not just the judiciary, but even if you see as per the international recommendations, our prison staff is hugely understaffed. Then there has been delay in investigations because even the police staff, they are either there are issues of corruption, deep-seated negligence, or on the other hand, people who are working, they are overburdened and they are overworking. So even this issue has been of prominence. There has been an inadequate prosecution system, so that has remained ineffective. Extreme poverty leads to them, people who are in jails not being extreme poverty leads to them not having a proper legal counsel and knowledge, right? So this is a very big issue amongst under trials. Illiteracy, that I've already discussed, and issues with the bail system. See, the CRPC Act of 1973, it does not define what a bail is. It defines what is a bailable offence, what is a non-bailable offence, but the formal definition of bail is not there. So there are persistent issues with the bail system, and that is something that needs to be worked upon, right? So these are the couple of reasons why there has been a delay in our justice system. Now there are a couple of detailed Supreme Court like guidelines that have been given. As per in 1980 Supreme Court said right to fair and speedy trial is the fundamental right of a person under right to life of Article 21 of the Constitution, right? So Supreme Court has already directed this. In May 2021, Supreme Court gave a couple of other guidelines. In State of Bihar case, Arnesh Kumar versus State of Bihar case, Supreme Court said adhere to the norms. Adhere to the norms in which if the person who is jailed, who is caught by the policeman, if the offence for which they have been accused of, for which they have been caught, if the period of that offence is less than 7 years, they should be considered for bails, right? Bail bonds. They should be considered for bail bonds. Then section 436A of CRPC, Code of Criminal Procedure, CRPC. The inmate who has completed half of maximum prison term that has been subscribed for the particular offence may be released on the basis of personal bond. Then the idea of house arrest was proposed by Supreme Court. It was just an idea about the house arrest, that just to prevent the overcrowding of prisons. If your prisons are overcrowded, there are a lot many people and you do not have furthermore space, so even the process of house arrest can be a perspective. So even in COVID, SC pushed for it, Supreme Court pushed for it, but there were a couple of people who opposed about it, so everything went down the drain. But here we are, what we are discussing. Now Supreme Court has given a couple of directives as well about the whole prison reform system. So they have given 8-point guidelines that came in 2013, right? What were the guidelines? The under trial review committee should be formed in every district and they should meet every quarter, right? They should meet every quarter and discuss what has to be done, what is to be done, and what is the present condition of the prisons in our district, right? They should, the under trial committee that will be formed, they should specifically look into the aspects pertaining to section 436 of CRPC. 436 of CRPC we've just discussed in previous slide, right? Now, State Legal Services Authority, they should be active. They should make it a point that the people, the inmates who are there, inmates I guess is the wrong word, the people who are still waiting their trial, they should get proper legal counsel, right? They should know what they are, what are their rights, what are the options available to them. So the State Legal Services Authority, they should make it sure that they get proper legal counsel. Now, District Legal Services Committee. District Legal Services Committee, they should release the under trial prisoners in compoundable offences. Compoundable offences as in chote, if they have done multiple petty offences, they should be released in that case. Now, in Bhim Singh versus Union of India in 2014 case, Supreme Court set a deadline of 2 months. 2 months and directed district judges and prison officials to oversee process of release of under trial prisoners who have already served half of their probable maximum prison sentence. So this was a landmark judgment by Supreme Court of India. You can quote this in your answers, right? Now, what sort of impact it leaves on a prisoner and his extended family? Let's discuss this, because the legalities of it we have discussed, but it also impacts their social structure, the social life. So we have to discuss that as well. Economy. See, a lot of prisoners, around 62% of the prisoners that are waiting under trial right now become to the youth category, which directly impacts our demographic profile, the demographic dividend of India. आप इतने सारे youth को निकाल के जेल में डाल रहे हो and they are sitting there idle. They are not the active part of the workforce of the country. So the huge impact it has on the economy of the country, that is totally unaccounted for, right? So the second impact, it comes on your family. Family mein there are two aspects. A, the males are majorly, if they are young, they are the only earning member of the family. If there is a single male in the family and he is the only earning member, that impacts. Also, once the person has been to jail, it changes the person. You're not the same person once you come back from the jail, because as quoted popularly, India's jail system is not for the reformation but the formation of criminals, right? It has been quoted times and again. So once the person comes out of jail, it becomes really difficult for the person to reconnect with his family, and there it causes a lot of turmoil. It has impacts not on your physical health, just your physical health because of the dire conditions, but also your mental health. Now, there is a social stigma attached to it. Everywhere you go, that stigma, that taboo, the flaw will follow you. Arey, ye to jail se aaya hai, right? And the person is considered to be dangerous and is sidelined from the society. So social stigma, it acts in a negative way. It violates your human and your constitutional rights. So waiting, a person who has to wait for a long period of time just to know whether you are innocent or you are being sentenced, it violates your human and your constitutional right. Then prison resources, it actually very adversely impacts your prison resources. Someone who is innocent and is in jail, right? If he stays there, he is consuming food, more number of security personnel have to look after him, right? And other sort of resources that have to be provided, that is an utter wastage, right? So this is wastage and unnecessary consumption of prison resources, which ultimately puts burden on your prison administration as well, right? There have been a couple of observations all over the country. So in I've already told you, in 1980 Supreme Court directed the right to free, fast and speedy trial, free, fair and speedy trial is fundamental right under right to life and liberty by Article 21, right? So in Husainara Khatun versus Home Secretary Bihar, it is said if if innocent is kept in jail, it violates your human rights, right? And it violates this constitutional right of a person. Now, right to bail is denied many times. The right to bail is denied even in genuine cases, as it was noted in Supreme Court versus Supreme Court in Motiram and others versus State of Madhya Pradesh, right? Also, it was mentioned in the under trial section of Law Commission's report, 78th report. So these are the places where under trials have been coming up prominently and their issues have been discussed. These are the points you have to remember while writing your mains answers. So please keep a note of them somewhere, make separate notes for your prison reforms and whatever guidelines are coming. Prison reforms is a very short topic, limited news आती है पूरे साल में. It's a blessing in disguise, अभी लगातार आ रही है. So keep making notes. All these you can jot down and quote them in your answers, right? And the third observation was, police, they sometimes produce only papers and codes, which violates the mandate that has been given by the Constitution of India and CRPC, that a magistrate won't assign any sort of punishment until and unless the person is produced before the magistrate. But police personnel, due to one reason or the other, whether it is corruption, whether it is lack of resources, whether because of some reason, they only produce papers, which hampers the judicial trial process, right? Now, these are the government initiatives that have been taken for the reformation of the prisoners. Fast track courts have been set up to speed up the resolution of cases, right? Then mission mode programs for delivery of justice and legal reforms, right, which is popularly known as under trial program, it has been set up. Now, concept of plea bargain has been put forward through section 265 of CRPC. See what plea bargain is. Plea bargain is, you admit to your crime that you have done this, and you can, before the case goes to trial, you can sit with a magistrate, with your lawyers, you can discuss a deal, sort of deal with policemen, that they will give you no sentence or reduced amount of sentence in exchange for some information you provide them, which could help them either bust more criminals or crack more cases. So the concept of plea bargain has been promoted a lot by section 265 of CRPC. West में, especially in US, it is very prominent. Everyone opts for plea bargain because it helps you with the reduced sentence. India mein it is not that popular, but it has been pushed by CRPC. Now, it was the concept of plea bargain has also been encouraged by NALSA, your National Legal Services Authority, within the CRPC parameters, right? So this has been also promoted. Now, section 436A we have already discussed, twice or thrice we have discussed, so I guess this point is clear. Now, free legal services, they are to be provided to all under trial prisoners by NALSA, irrespective of what their social status is, what their religious status is, or what sort of crime they have given. The right to free and fair trial is their fundamental right. So NALSA has to make it sure that they receive it, right? Now, there are a couple of recommendations that you have to write in your answers. So this is the way forward. Law Commission recommendations that have been given in 268th report. Please go through them. There are a couple of 8-point guidelines. So just Google them, or you can find them in the Law Commission's report under trial section. So that has to be implemented. That is one of the major things that can be done to reform the current condition of the prisoners of the country, then an under trial review committee can be formed, where the people who have not done heinous crimes can be released on personal bonds, bail bonds, or can be given reduced sentences or alternative sentences, or can be released altogether if they have shown good behavior, better reformative behavior in their jail tenure, right. Legal service authorities should capture as many people as possible in the domain of people who need legal services, legal advices, right. So this agencies, they should make it sure that they work at their optimum level, and we have to expedite finally the trial process. The trial process in India, which takes around 15 months to 20 years, that have to be expedited. We have to employ more personnel in police and judiciary, so that people who are separated from their families, especially, justice is not served at the cost of innocence of anyone, right. So that should be taken into consideration. These were your 3 major topics that we have covered for today. If you have any doubts, you can mention them in comments. I'll try taking them up in the next session. That is all for today. Thank you so much. Stay tuned and keep learning, keep watching. Bye bye.